Justice Samuel Alito wrote the majority opinion that overturned Roe. Justice Clarence Thomas voted with the majority and wrote a concurring opinion that is getting a lot of attention for one particular section. Quote, in future cases, we should reconsider all of the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. For those who don't have the 3 landmark rulings memorized, they ensure that Americans have the rights to contraception access, same-sex relationships, and same-sex marriage. We're back with Amy Howe, co-founder of SCOTUS Blog, Megan Hatchett-Mays, director of democracy policy for Indivisible, and Mark Joseph Stern, senior writer for Slate, focusing on courts and the law. Amy, I want to ask you, that seems so stunning of a transmission of what they believe eliminating Roe does for a blueprint for other laws and other rights to eliminate. What do you say to that?
I mean, I think that's right. That was one of the real surprises today, actually. After the draft opinion, it wasn't a surprise that the court overruled Roe and Casey. And the court in that draft opinion, which we'd already seen, had in essence tried to provide assurances that abortion is different from rights like the right to same-sex intimacy, the right to same-sex marriage, the right to contraception, because only abortion involves the termination of life. The dissenters pointed out that those rights fall under the same broader right to privacy on which the right to an abortion rested. And so the dissenters said, in essence, watch out for what's next. And Justice Thomas, it was a solo concurring opinion, to be sure, but said in this decision, I don't believe that there is a right to what's called substantive due process, that the Constitution protects these unenumerated rights. And I think even though we didn't have to decide that issue today in this decision, I think we should take up these questions in future cases.
And I think that's, Megan, what I find the most stunning is this outline of what the erosion of our rights are happening right in front of us, and they're going to continue. So what do you say to individuals that say, well, I think that if the law wants to interfere on a woman's agency right to choose, it really doesn't impact me? What do you say to those people?
Of course it does. Basically, if there's a right that you care about, a constitutional right that you enjoy that is not explicitly written down in the Constitution, it's at risk. So what we know is that if you're a corporation or a gun, you're good. But if you're neither of those things, good luck. We're all in trouble. And it goes to what you've been talking about here, and what Amy was just talking about, is that there's all these other rights that are underpinned by the same legal principles that underpin Roe and Casey. So all of those things are now at risk, regardless of what, Alito says or what John Roberts says. John Roberts is a real king of public relations. He wants to do bad things. He just doesn't want anybody to notice that he's done them. So he wants to minimize what he thinks is going on here, which is why he came up with this ridiculous compromise for keeping this Mississippi law in place. It does harm to people. This court is doing harm to people, and they are not ever going to stop. Again, this is kind of like the zenith of their right-wing project to overturn Roe v. Wade. But, who knows what's next beyond contraception and same-sex relationships and interracial marriage? They could go after Brown next. I mean, we've already seen these culture wars crop up in schools. It really does raise some questions about which Supreme Court precedents are truly safe. In my view, none of them are, because that's what this conservative legal movement has been about since the Reagan years. And so this is a very scary time. And so if there are people sitting at home thinking, well, I'm good, I can't get pregnant, so this is fine, think again. This is a problem.
So following up on that, Mark, Alito's opinion claimed that the right to contraception and same-sex marriage aren't at risk at all. But Thomas points out that they might be. Can we really be at a place in America where one day a woman cannot have contraception?
So I don't think that this would begin with an outright ban on, say, birth control pills. But what we're already seeing, and the dissenters note this in their opinion, are red states trying to reclassify common forms of contraception as so-called abortifacients that terminate a pregnancy in its very first stages and outlaw those on the grounds that they're actually abortions. Those include Plan B, IUDs, other forms of contraception that conservatives claim allow for an egg to be fertilized. Scientists generally disagree with that, but this Supreme Court has been very deferential to the beliefs of red state legislatures, and especially evangelical Christians. So I do think that it's within the realm of possibility that we would see states begin to roll back access to contraception, not just for legal adults, but also for minors. And that was one of the big fights that the Supreme Court actually had in the wake of Roe, was whether minors had access to contraception. The court said yes at the time, but of course, its decision was rooted in the same doctrine that was repudiated wholesale by the majority of the court today. So I think there is a real possibility, not a certainty, but a possibility that within the next few months and years, we will see legal limitations on access to various forms of commonly used contraception in Republican-led states.
So I want to follow up just more on the tone of this, because I think that we're all a little bit of shock in trying to figure out what does this exactly mean for all the other rights that we have laid out on the table that Thomas has outlined. So I want to ask you, someone who covers SCOTUS all the time, what is the mood inside of that courthouse right now after this dissent by the 3 liberal judges who represent the majority of Americans? Amy?
So the mood at this time of year at the Supreme Court, even in the best of times, and clearly this is not, from their perspective, the best of times, tends to be frayed. The justices are all working overtime to try and get the decisions out. And you always sort of sense some tension. And we have seen this term, there was the debate over masks at the court, for example, when all of the justices, except Justice Gorsuch, showed up when COVID was at its peak in January wearing masks. Justice Thomas gave a speech last month talking about how much better the court used to be, in essence, before the Chief Justice arrived. He said that the court that we had up until the 2005 for 11 years with Justice Breyer as the junior justice was fantastic, and that's really changed. And you also saw it, truthfully, at the end of the dissenting opinion today. One of the common courtesies that the justices normally use in their dissents is to use the phrase, "I respectfully dissent." And here they did not use that phrase. They said, with sorrow, we dissent.
So, Amy, just to quickly follow up on that, do we have any idea who leaked this beforehand? Was it on the conservative side?
We have no idea. And I think this is one of those things that you can certainly argue round or flat, depending on what you think that the purpose of leaking it was. But I think what we did see today was that if the purpose of leaking it was to try and change the minds of one of the 5 justices who voted back in December to overrule Roe and Casey, it clearly did not have that effect.